The first matter to come before the court this morning is State of Ohio versus James Bressi. Both sides will have 15 minutes to argue this morning. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started. I'm keeping the clock this morning, and I can keep you apprised of the passage of time. We have read the briefs and we're ready to proceed when you are.
Thank you, Your Honor. Mike Callahan here on behalf of the appellant, James Bressi. Good morning, Your Honors. We filed a brief. You've read the briefs. I know you have. There's 3 areas of contention that we have brought forth. 1 is the manifest way of the evidence. 2 is I will call the discovery issues, and 3 is the no cooperation issue of the, I'm sorry, Your Honor, I'd like to reserve 5 minutes.
Certainly.
No cooperation of the sexual imposition, the only offense that he was convicted of, a misdemeanor of the 3rd degree. If it pleases the court, I would like to start with the discovery issue because it is, although not first in my brief, it is perhaps first in time in the progression of the case. There's no doubt there were problems with discovery throughout this entire case.
And you're referring to the missing reports.
Tapes and tape statements.
Tapes and statements.
I guess I don't know whether there's missing reports or not, but certainly there have been allegations throughout. The entire case was fraught with having problems getting discovery. And let me preface this by saying that I do not make accusations against the prosecutor's office. I believe the prosecutor's office worked as diligently as they possibly could with me.
We all realized there were lots of people and lots of statements and lots of information. It was a complex paperwork situation.
No doubt about it. I think that the assistant prosecutors working on the case worked diligently to get me what they had. It is my contention that they were not given all the discovery.
And so could you clarify for me the precise set of facts that we're talking, the narrow facts that we're talking about here, and demonstrate the prejudice that you're claiming?
Yes, I will get directly to that point then because of the time limitations. Because of the problems in getting discovery, we hired a private investigator to go out and talk to alleged victims and people that were in discovery to see whether or not they had given tape statements. Based upon the testimony of at least 8 of them, including 2 or 3 that were in the indictments, that told our investigator that they did in fact give tape statements to the Stowe Police Department. We came forth with requests for that and were told they didn't exist. Then during the course of trial, actual testimony of at least 5 or 6 of those alleged victims, including the woman whose case was resulted in a conviction, said that they were taped and that they had given tape statements. Those tape statements were never provided to us. I will tell the court that based upon the testimony of this woman that resulted in a conviction, her actual testimony, there's some questions of her memory, there's some questions of what she testified to on direct, and then subsequently had to admit on cross-examination that would at the very least question her memory, and at the worst question her veracity. And had I been provided, had the defense been provided a copy of whatever tape statement she made at the time she made that statement, which would have probably been a year before, it certainly had a potential of being Brady material.
Is it clear in the record that she gave a statement, a tape statement?
There is testimony from our investigator under oath prior to the trial commencing that she told him that she had given a tape statement.
And that there was a reporter there or a videographer there.
I don't believe there's anything like that.
Okay, well, when you talk about tape statements, that's what I'm trying to understand is she may have given a statement, but there was no one there other than the investigator who was interviewing her.
Oh, that's correct. Various witnesses testified throughout the course of the trial that the investigator or one of the investigators walked in, pulled out a recording device, sat down, asked if that was okay if they'd be taped, and
But
they
that
said
didn't
yes.
happen in the case of your client.
My client?
Excuse me, in the case of the defendant.
You mean the
The witness.
I believe there was testimony that it did.
Okay,
Testimony from our investigator who interviewed her.
all right.
Okay? So it is our contention that this lack of forthcoming of these tape statements after the witnesses continually testified to the fact that they existed and that they had given tape statements prejudiced my client and was obvious Brady material.
Did the trial court hold a hearing? I'm trying to recall from reading the briefs, perhaps you filed a motion to dismiss or a motion for something?
I filed a motion to dismiss and in the alternative a motion for a continuance to further explore this information because it came forth at the very last moment.
And did
There
the
was
trial
a
court
brief.
hear?
There was a brief hearing, and I will, interestingly enough, I will point out for the panel that they called our investigator, Mr. Tim Dimoff, placed him under oath to testify, and then called Detective Swanson and did not swear him in and place him under oath. I'm not sure that has a lot of bearing on this, but
Was there
he
an objection made to his being, the detective not being placed under oath?
Your Honor, I don't recall. I'll be very honest with you. I find it hard to believe that I wouldn't have, but I don't recall.
And I raise that because in reading the entry, the court's entry, it sounded as if the court made a credibility determination that the witnesses were not clear on whether or not there was a recording device. Am I right about that?
Your Honor, you are right, however, let's put it in context. The court made that ruling prior to the commencement of the trial. When the trial commenced, then there were numerous witnesses that came in under oath and testified again. More than I or my investigator envisioned or were aware of. But we got to the point where we asked every one of them, and I think 6 of the 11 women testified that yes, they were taped, and were fairly consistent in how they were taped. Your Honor, I don't want to run out of time. I at least want to get to my second issue on the no cooperation. It is clear that for a conviction of sexual imposition, there must be some evidence of cooperation. It is our contention that there was absolutely no evidence whatsoever in this case of any cooperation by a witness, by a witness stand, or by documentary evidence.
And your client made a comment, and I didn't write it down, I should have, suggesting that something may have happened, or it could be viewed as though something had happened. Am I correct?
I don't believe so, Your Honor. I think my client, there's a distinction between my client's case and what the state has tried to put forth in the recent case this court brought out in the caption of your case.
So your client disavows any inappropriate touching?
Absolutely.
Other than he may have had his hand in a certain position in connection with...
A medical procedure, an acceptable medical procedure. In the state of Ohio, Summit County in Ray J.H., there's an absolute distinction. That was something recent. In that case, the defendant actually admitted doing what was done, and I believe said it was consensual. And that was found to be sufficient for cooperation. Here, the witness testified that she told someone. However, she also testified that the first time it was actually recorded by anybody was 13 or 14 or 15 months later when she told the police. She did testify on direct that it was a month later, but when confronted with the facts, had to admit on cross that it was 14 or 15 months later that she had told the police. I believe that the state would have you believe that her testimony about telling her husband or telling Dr. Geiger is enough for cooperation. I submit to you, you cannot self-cooperate. Had the state brought in Dr. Geiger, who was on the witness list, who was subpoenaed, who was actually in the courthouse, had they called him as a witness and he came in and was subject to cross-examination and said, yes, that occurred, that would have been cooperation. I understand it.
Wasn't there another staff person who was either called as a witness or gave a statement to the detective that the victim in this case had spoken to Dr. Geiger the next day and had about some inappropriate activity?
And I will tell, Your Honor, that that is the allegation set forth by the state, but if you read the transcript of her testimony, it has nothing, it says something to the effect of, he spoke on inappropriateness of, or illegal activity of Dr. Bressi, with no reference to when it was, who it was, what it was about, whether it involved Carol Hudak or not.
Well, the case law on this area of corroboration as it's developed makes it seem as if the corroboration needs to be pretty slight.
I would absolutely agree. In the economy case, it pretty clearly sets forth the Fitzgerald case that they cite in the economy case, United States versus Fitzgerald, where they talk about the timing of it. Does say that it has to be in relative recent time. I don't think 14 months is going to cover that.
And counsel, you are just now reached in and answering, so you're about 3.5 minutes remaining. Just want to let you know.
In that case, I will finish up by saying that my third assignment of error, Your Honor, is on the manifest weight. I think if you look at the first two assignments and the totality of all the evidence that's set forth and the circumstances as the verdict came out, that there was basically no evidence whatsoever for the jury to have rendered this verdict, and I would ask the court to set aside this verdict. Thank you.
May it please the court, Richard Cassay representing the state of Ohio in this case. Talk about discovery for a short while. Number one, the court, Judge Parker, had 2 hearings on this issue. One prior to trial and one during trial, and he issued a fairly lengthy written opinion. He found as a fact there was no discovery violation. There was nothing withheld. Everything that existed was given to Mr. Bressi. He found that as a fact after personally viewing the Bressi's private investigator and the Detective Swanson.
He found that there was no willful violation. Did he also find that
There wasn't anything, the so-called missing recorded statements, he found there were none. There are none that were not given over.
And that finding was made during the first hearing and the second hearing regarding the discovery?
The journal entry overruling the motion to dismiss was filed after the evidentiary portion of the trial. So this was not something that the court, Judge Parker, made an early decision on, and then we have new revelations that Judge Parker did not have a chance to consider. That's not true. Dimoff testified prior to trial. The detective was called during the trial because there was an issue with one of the witnesses who was not Carol Hudak, by the way. So the detective was put on the stand, and after all the evidence was in, the court files its entry. So the court knew everything there was to know about this.
Do you agree with your opposing counsel that Ms. Hudak also testified under oath that when she was interviewed, that there was a recording made?
She recollected that there was a recording, but you have to keep in mind, number one, there are numerous civil suits going on with this, and that's in the record. So I don't know what she was thinking about, but the detective said, and Judge Parker believed him, no recordings are missing from the criminal discovery. Now that's the foundation for all of this. Over top of that, there's only one conviction, Carol Hudak. Everything else at this point is moot. There's no prejudice when the defendant is acquitted. And I cited a case for that. Number three, what did Carol Hudak testify to? Well, the court knows what she testified to. Dr. Bressi admitted that conduct. He said she has a right for her allegations. That's his phrase. He admitted putting his hands on or near her vagina. He admitted poking her hand with an object. She said it was his penis. He pulled out some kind of a little water bottle and said, oh no, it was this. So, but the conduct, what she testified to, and he knew she was upset, he knew she was crying, he admitted the conduct. The question is, was it sexual contact offensive to Carol Hudak under the statute? But what happened, there's really no dispute. So, cross-examination of Carol Hudak. She did not remember when she talked to the police. She thought it was in 2012. It was actually about a year later in 2013. She was fully cross-examined on that. And the jury made a credibility determination on her testimony. Carol Hudak gave a written statement. Mr. Bressi, Dr. Bressi had it. He used it to cross-examine her. There's nothing to this discovery violation. And Brady has no application whatsoever because all of this came out prior to or during the trial. Now, if there are no further questions on the discovery issue, we'll move on to collaboration. JH, in the state's opinion, is good precedent for this case because, here's a quote, JH never disputed that the foregoing incident occurred. As I say, Dr. Bressi essentially admitted what Carol Hudak had testified to. The only question is offensiveness. And was he reckless in that regard, knowing it would be offensive to her, or did he know it? Well, of course he did. This is all, first of all, it's all sufficiency. Cooperation is an aspect of sufficiency. This is something for the trial court to determine. I don't even know if it belongs in a manifest weight review. Because the law is, it is an aspect of sufficiency to be determined by the trial judge. And that's what occurred here. So again, I think there's an issue of whether or not it's even appropriate for a manifest weight review because it's not a jury question.
Are we going to find in the record the ailment or whatever Ms. Hudak was experiencing that caused her to be treated by Dr. Bressi? In other words, did the jury have an opportunity to consider that she said she had, shoulder pain, and yet, the manipulation was in the groin area? Do you understand what I'm saying?
Yes, I do, and I can't give you a specific, but I'm sure Mr. Callahan thoroughly cross-examined her on Dr. Bressi's prior manipulations of her body. And that occurred, there's no doubt. This is not the first time that Dr. Bressi put his hands on her. but it is the first time that it went to this degree. She was upset. He had to know, again, under a sufficiency issue, he knew that this was offensive. She was crying, she was upset, she was trying to get up, he pushed her back down. She's trying to ball her hands up, she's trying to move her hands. He's grabbing her hands and sticking them back down. He pulls her scrubs. She was wearing scrubs, she's a nurse. They get pulled down, his hand goes near her vagina. She says, enough, whoa. That finally stops him. But she had given him plenty of reason prior to that to know, not to be reckless, but to actually know that this was offensive to her. And what did he say afterwards? Get your husband and go fuck your brains out. That's what he said. He was doing it to give her release. His own words, as testified to by Carol Hudak. So there's plenty of corroboration. Tricia K, I believe, the employee, she said, yes, the next day, Carol Hudak talked to Dr. Geiger about illegal conduct. Well, the only illegal conduct that is in this record is what Carol Hudak testified to, the so-called manipulations by Dr. Bressi. So that is corroboration.
And was that testimony presented at trial?
Yes. It's quoted in Mr. Callahan's reply brief. It's not lengthy, but were you present when Carol Hudak talked to Dr. Geiger about illegal conduct? Yes, I heard it. The next day afterwards. Corroboration is some evidence, slight evidence tending to support. Slight tending to support. Not very much. There's more than sufficient corroboration here. Again, we're talking about a sufficiency test. Judge Parker went through it. He put in things I haven't even talked about, that after this incident, the procedure in the office was changed. So this type of procedure is not going to be done behind closed doors. Dr. Bressi ended up being fired from his job. Dr. Geiger told Hudak that he would back her up. Dr. Bressi admitted that...
Did you say Dr. Geiger told her?
Dr. Geiger told Hudak, and Dr. Bressi, during his testimony, said he knew, he was aware that Dr. Geiger was aware of something that Bressi had done that was not above board.
But Geiger did not testify.
Geiger did not testify, and I do not know why. But Bressi admitted it. So, is there corroboration sufficient under the statute? There is no question that there is. JH points out, to reinforce a point I made in the state's brief, the state is not required to produce every conceivable bit of corroboration that someone with hindsight might imagine. We do not have that duty. There's more than enough here. And if there are no further questions, I'll conclude.
I have a quick question referencing that part of the testimony from the witness. The question that's posed, at least in the context of the reply brief, is question, were you present when she had a conversation with Dr. Geiger about Dr. Bressi and some illegal conduct?
Yes.
There's no time frame related to...
It's the next day.
Well, I know that is somewhere else in the record that's the next day, but the question doesn't have a time frame. Are we going to find in the record that the time of that conversation has been established through this question and answer with this particular witness?
If you're asking, can you speculate that she's talking about illegal conduct that occurred a year before? No.
No, not when the illegal conduct occurred, but when the conversation
The
occurred.
next day.
Okay.
Your Honor, if you're looking for what time of day,
No, I'm not, counsel. It's just the question to that particular witness about a conversation that was had. There's no time frame on the conversation. And I understand that there's other testimony, most likely in the record, from Ms. Hudak that puts a time frame on that question.
Yes, I see your point. The exact quote does not have a time frame on it. Hudak testified that conversation occurred the next day. Does that answer your question? There's not a time frame in the quote.
But there's not a time frame from that witness?
Correct.
Okay, thank you.
All right. If that's all, I'll conclude. Thank you very much.
Thank you. Counsel, you have just over 3 minutes remaining for rebuttal.
Thank you, Your Honor. May it please the court, just a couple of quick responses. I'll start with what you ended up with on the Tricia Kay testimony. I would just ask Your Honors to look at her testimony. I've read it. I do not have the entire testimony in front of me. But I think what you're going to find, and I certainly don't want to argue with my colleague here, but I think what you're going to find is Tricia Kay does not put anything in any context whatsoever as to when this occurred. And I think why is that important? Because you'll see that while counsel is correct that there is someplace else in the record where it says that, there's also numerous places elsewhere in the record where they talk about the goings-on at Summit Painting and the allegations over the course of 18 months against my client. So it could be any activity that Tricia Kay was talking about when she talked. There's no time or reference to any specific activity or any specific time frame in her testimony. I think that's important because, again, I go back to App.No. It does say that it doesn't have to be much, but it says there has to be evidence. And I submit to the court that there was no evidence whatsoever that corroborates Carol Hudak's testimony, but her own self-corroborating testimony. I would also just take a moment and distinguish what I believe between JH in this case. Page 13 of the opinion on JH. JH never disputed that the foregoing incident occurred. On page 14, he describes the encounter as being consensual. Your Honors, he's basically admitting in his case, in that case, that he committed an offense. Dr. Bressi did no such thing. Dr. Bressi said he was involved in a medical procedure and explained the medical procedure, gave direction and brought experts in to talk about how that medical procedure occurs and what it's for and how it works. And I think that's easily to distinguish those two situations.
Let me ask you what I asked your colleague here, what your recollection from the record is as to the problem, the medical problem that the doctor was addressing.
I think it would be important to note, if you read the entire testimony of Carol Hudak, she was upset prior to it commencing.
No. I mean what it was that he was treating.
I think if you look throughout the entire course of the transcript, he did a type of orthopedic manipulation that was sometimes referred to as massage. I think our experts said incorrectly referred to as massage. And that manipulation basically put your neck and back and spine and everything back in order, and how there was a much longer than I will ever have to explain now, and I'm certainly not medically trained for it, but there was a great explanation by the expert and by Dr. Bressi about how manipulating something in one part of the neck, for example, might affect the back, and one part of the back might affect the spine or the legs. And so, just because your pain may be here, and I'm pointing to my neck, does not mean that that is where you need to manipulate something to alleviate that pain. And with that, I suspect I'm about out of time. Thank you, Your Honors, and I would ask to reverse and remand this case. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. You can link to that website through the 9th District website if you wish. Thank you.